Do lawful permanent residents have Fifth Amendment rights? We explore that question in the case Kwong Hai Chew versus Colding. Kwong Hai Chew, a Chinese sailor, was admitted to the United States as a lawful permanent resident effective 1945. Chew petitioned for naturalization in 1950. Several months later, the Coast Guard approved Chew to work as a seaman aboard a merchant ship. Chew was later assigned to work aboard the SS Sir John Franklin, which was registered in the United States and maintained its home port in New York City. Upon returning to the United States following a voyage aboard the John Franklin, an immigrant inspector ordered Chew temporarily excluded on the grounds that he was an alien whose entry into the country was prejudicial to the public interest. A federal regulation in place at the time provided that certain excludable aliens could be denied a hearing if the Attorney General determined that the alien was excludable on the basis of confidential information, the disclosure of which would harm the public interest. The Attorney General denied Chew a hearing pursuant to this regulation and ordered that Chew be permanently excluded from the country. Chew was never provided with information regarding the allegations against him. Chew challenged his detention through a petition for writ of habeas corpus. The district court dismissed the writ. The Second Circuit affirmed. The United States Supreme Court granted cert. There, Chew argued that the regulation relied upon by the Attorney General didn't authorize him to deny Chew a hearing and notice of the charges against him. If the regulation did grant the Attorney General that authority, Chew argued that the regulation violated the Fifth Amendment and was therefore unconstitutional.